Everyone thought this case was slowing down, but what just surfaced changes everything. Because buried inside a new court filing is a fight over secrecy. That raises one uncomfortable question: what is being hidden and why? And when a judge is asked to keep key communications out of public view while those same messages are used to defend a case, it stops being about celebrity drama and starts being about transparency, power, and whether the truth is being filtered. And what happens next could reshape this entire story, so stay with me, because once you see how deep this goes, you will not look away. The reason this story refuses to slow down is because every time it seems like the public has reached the end of the road, another document surfaces, another argument is made, and another layer of secrecy is questioned. And this time the stakes feel higher, because the conversation is no longer just about disagreement or interpretation. It is about whether key material is being intentionally kept from public view, and whether that effort itself tells a story that no statement ever could. Because when a case reaches this stage, when filings are being debated not for relevance, but for visibility, it forces everyone watching to stop and ask why now, and why this aggressively, and what exactly is so concerning that it must remain hidden. And that question alone has kept audiences locked in, because transparency is the backbone of public trust in the legal system, and once that transparency is challenged, the focus shifts from personalities to principles. And that is exactly what happened the moment the latest letter from Justin Baldoni's side became public, because it did not argue emotion. It argued structure, it argued precedent, and it argued that once documents are used in court, the public does not need permission to see them, because the court itself is a public institution. And that concept is simple yet powerful, because it strips away celebrity influence and places everyone on equal footing. And that is where the tension begins, because equality under the law sounds straightforward until it is tested in high-profile situations where reputation, influence, and public perception all collide, and suddenly the standard rules feel inconvenient. And that is why this filing hit so hard, because it did not accuse, it questioned. And it questioned whether sealing tactics were being used not for protection but for control. And that distinction matters, because protection is narrow and control is expansive, and courts are built to reject the latter. And as the argument unfolds, it becomes clear that this is not about private messages accidentally exposed or personal data that should never be public. This is about communications that were voluntarily submitted to support a legal position, and once that line is crossed, the expectation of privacy fundamentally changes. And that is where many people seem to get confused, because discovery and filing are not the same thing. Discovery is broad and mostly private, while filing is selective and deliberate. And when something is filed, it is done with the knowledge that it enters the public record, unless a very high standard is met. And that standard is not embarrassment or discomfort or fear of backlash, because if it were, nearly every contested case would disappear behind redactions, and the public would be left with outcomes stripped of context and meaning, and that would defeat the purpose of open courts entirely. And that is why the letter emphasizes that sealing is not meant to be easy, because ease invites abuse, and abuse erodes confidence, and once confidence is lost, it is nearly impossible to restore. And that is what makes this moment so critical, because the court is being asked not just to rule on a request, but to reinforce a boundary and say this is where privacy ends and public accountability begins. And that boundary has protected the integrity of the system for generations, and when it is tested, the response matters more than ever. And what deepens the suspense is the fact that these communications are already known to exist. They are not hypothetical, they are not rumors. They have been reviewed by the parties and the judge, meaning the debate is not about whether they should influence the case, but whether the public should be allowed to see the same material that the court is considering. And that gap between what the court knows and what the public sees is where suspicion grows, because secrecy breeds speculation, and speculation thrives in silence. And the more resistance there is to disclosure, the louder the questions become. And those questions are not driven by malice, they are driven by logic, because if material genuinely supports a narrative, openness strengthens credibility while concealment weakens it. And that is not opinion, it is human perception, and courts understand that, which is why they are cautious when one side appears to want to benefit from evidence while shielding it from scrutiny. And that is what the sword and shield argument captures, because it speaks to fairness and balance. And judges historically have little patience for strategies that attempt to tip that balance under the guise of privacy, and that impatience is rooted in experience, because once such tactics are allowed, they spread, and soon every case becomes a negotiation over visibility rather than truth. And that is not sustainable, and that is why the filing draws such a clear line by stating that the public interest in transparency outweighs personal discomfort, especially when the communications in question are directly tied to the claims and defenses being argued, and that point alone reframes the entire situation because it suggests that this is not a side issue but a central one. And when central issues are hidden, it raises the possibility that the narrative being presented publicly is incomplete, and incompleteness is the enemy of trust. And as viewers sense that, they lean in not because they want drama but because they want clarity. And clarity feels just out of reach, and that is what keeps them watching. Because each new development promises either confirmation or contradiction. And both are equally compelling, and as the discussion continues, it becomes impossible to ignore the broader implications. Because this case does not exist in isolation. It sits within a media environment where celebrity influence is constantly debated and where public perception often feels curated. And when that perception meets the rigid structure of legal procedure, sparks fly. And the outcome of that collision sets a tone, not just for this dispute but for future ones, because if influence can successfully limit transparency here, it signals that fame carries procedural advantages. And that idea is deeply unsettling to anyone who believes the law should function the same, regardless of status, and that unease is palpable throughout the conversation because it is not just about what is being sealed but about what sealing represents. And that representation is what elevates this from a legal argument to a cultural moment. Because people are not just watching a case unfold, they are watching a principle being tested in real time, and that test has no easy resolution. Because it forces the court to balance competing interests while knowing that whatever decision is made will be scrutinized, dissected, and remembered, and that awareness adds weight to every word and every ruling. And that weight is why this story continues to grow rather than fade. Because it taps into a fundamental question about fairness, transparency, and whether the system can withstand pressure when it matters most. As the argument moves deeper, the focus naturally shifts from the abstract idea of transparency to the very real implications of what these communications may reveal. Because once the door is open to the possibility that influential figures were contacted, the case stops being a private dispute and starts looking like a broader examination of power dynamics within an industry. And that is where interest intensifies. Because influence itself is not illegal, but how it is used can shape outcomes and perceptions. And when messages allegedly involve outreach to individuals with significant standing, it raises legitimate questions about intent, state of mind, and strategy. And those questions are not speculative, they are central to understanding how events unfolded and why certain decisions were made. And that is precisely why relevance becomes unavoidable, because relevance is not about whether something feels uncomfortable, it is about whether it helps explain conduct and motivation. And courts rely heavily on contemporaneous communications for that reason, because they capture unfiltered reactions rather than curated explanations offered later. And that distinction matters because hindsight allows narratives to be refined, while real-time messages often reveal raw thinking. And when those messages are suddenly shielded, it naturally prompts the audience to wonder what they contain and why they are considered too sensitive for public view, especially when they are being cited to support legal arguments. And that contradiction is what fuels skepticism, because it suggests a desire to benefit from substance without accepting scrutiny. And judges are trained to detect that pattern because it appears in many forms, across many cases, and rarely ends well for the party attempting it. And as this plays out, the involvement of well-known figures becomes impossible to ignore, not because of who they are, but because of what their involvement implies, which is access and reach. And when access and reach intersect with a dispute over creative control or professional conduct, it becomes relevant to understanding leverage and influence. And those factors are not abstract, they can materially affect outcomes. And that is why the argument that these communications are merely private conversations falls flat. Because once they are used to advance a position, they take on a different character and become part of the evidentiary landscape, and the law recognizes that shift, which is why the presumption of public access attaches and requires a compelling justification to overcome. And that justification must be specific, narrowly tailored, and rooted in genuine privacy interests, not general discomfort or fear of reaction. And that standard exists precisely to prevent selective disclosure. And when observers see a broad attempt to seal entire threads, it signals overreach. And overreach invites pushback, and that pushback is now playing out in real time, with each filing adding pressure rather than relief, and the tension escalates further. when the discussion turns to timing because timing often tells its own story, and the effort to limit disclosure appears to intensify as scrutiny increases, which creates the impression of defensiveness. And while impressions are not evidence, they influence how actions are interpreted, and legal strategy must account for that reality. Because judges are human and so is the public, and when a strategy seems designed to manage optics rather than clarify facts, it can undermine credibility, even if unintentionally, and that risk is amplified in high-profile cases, where every move is dissected and contextualized, and that is exactly what is happening here, because viewers are not just absorbing information, they are evaluating patterns. And those patterns suggest a growing gap between what is known within the courtroom and what is shared outside of it, and gaps create narratives of their own. And those narratives are difficult to control once they take hold. And that is why transparency is often the safer route, because it limits speculation by replacing it with facts, and facts, even when unfavorable, tend to stabilize discourse while secrecy destabilizes it. And as this dynamic unfolds, the court becomes the final arbiter, not just of legal standards but of public confidence, because its rulings signal whether openness remains the default or whether exceptions can expand under pressure. And that signal will resonate beyond this case because it informs how future litigants approach disclosure and sealing, and whether they view the courtroom as a place of accountability or negotiation over visibility. And that distinction matters deeply because the legitimacy of outcomes depends not only on correctness, but on perceived fairness, and perceived fairness is inseparable from transparency. And when viewers sense that information is being withheld, they question not just the parties but the process itself, and that questioning erodes trust incrementally but persistently. And rebuilding it is far more difficult than maintaining it. And that is why this moment feels consequential, because it is not just about what happens next but about what standard is reinforced or weakened. And that weight hangs over every argument and every decision, and it keeps audiences engaged, because they recognize that something larger than a single dispute is unfolding, and they want to see whether the system holds its line or bends under the strain. And that uncertainty is the engine driving attention, because resolution feels distant, and each development adds complexity rather than clarity. And as long as that remains true, viewers will stay watching, waiting to see whether openness prevails or whether influence reshapes the boundaries of public access once again. As the case continues to unfold, the conversation inevitably shifts toward what the resistance to disclosure may signal, because in legal analysis, actions often speak louder than arguments. And when significant effort is expended to prevent material from entering public view, it invites interpretation, whether intended or not. And that interpretation becomes part of the broader narrative surrounding the dispute. And this is where the story takes on an almost psychological dimension, because observers begin to analyze not just what is being said but what is being avoided. And avoidance is rarely neutral, it suggests calculation, caution, or concern. And when layered on top of a high-profile conflict, it becomes fertile ground for speculation, and that speculation is precisely what transparency is designed to prevent. Which is why courts generally favor openness even when the outcome is uncomfortable. And that preference is not arbitrary, it is rooted in the belief that sunlight stabilizes trust while shadows distort it. And as viewers absorb the arguments being made, they start connecting dots between what is claimed publicly and what is allegedly contained privately. And that gap fuels curiosity, because humans instinctively seek coherence, and when narratives feel incomplete, attention intensifies rather than fades. And the more complex the situation becomes, the more viewers lean in, searching for clarity. And that clarity remains elusive, because each filing seems to raise new questions instead of resolving old ones, and that perpetual motion keeps engagement high, because resolution feels perpetually just out of reach. And as the debate circles around relevance again, it becomes clear that relevance is being narrowly framed by one side while broadly framed by the other, and that contrast is telling, because narrow framing limits exposure while broad framing invites examination. And courts historically lean toward the latter, especially at stages where understanding context is critical, and context often resides in communications that reveal relationship strategies and reactions, and those elements cannot be fully appreciated in isolation, which is why sealing entire conversations risks stripping meaning from the record and leaving only curated fragments, and curated fragments rarely tell a complete story. And that incompleteness undermines the court's ability to assess credibility, which is central to many disputes. And as the public watches this dynamic play out, they begin to sense that what is being debated is not merely content, but control over narrative, and narrative control is a powerful force. especially when public opinion can indirectly shape professional consequences, and that reality adds another layer of tension because while courts insist they are insulated from public pressure, they operate within a broader ecosystem where perception matters and litigants know this, which is why strategies often extend beyond the courtroom and into the court of public opinion, and sealing requests can function as tools within that arena by limiting what can be discussed, analyzed, or critiqued. And when that limitation is perceived as strategic rather than protective, it triggers backlash, because audiences value authenticity and react strongly when they feel managed rather than informed. And that reaction can snowball because online discourse amplifies emotion. And once suspicion takes root, it spreads quickly and becomes difficult to contain, and that is why some legal analysts argue that overuse of sealing is counterproductive, because it invites exactly the scrutiny it seeks to avoid. And this case appears to illustrate that paradox, because the more aggressively secrecy is pursued, the more attention is drawn to the very material being hidden. And the louder the questions become about its contents and implications, and those questions persist because no clear explanation satisfies them fully, and partial explanations often deepen uncertainty rather than resolve it. And as the discussion broadens, it becomes impossible to ignore the imbalance between what parties inside the courtroom know and what the public outside is allowed to see, and that imbalance feels especially stark in a case that has captured widespread attention, because interest is not limited to legal professionals but extends to a general audience, invested in understanding how power operates and whether accountability applies evenly. And when that audience senses asymmetry, it reacts not with apathy but with heightened engagement, because asymmetry suggests something is at stake, and stakes drive storytelling. And this case has become a story precisely because it embodies conflict, tension, and uncertainty, and those elements are amplified by the slow drip of information that characterizes contested litigation, and each new development functions like a chapter that reframes what came before and hints at what may come next. And as long as sealing remains unresolved, it serves as a narrative anchor, because it represents the unknown, and the unknown is inherently compelling, and viewers stay because they want to see whether the unknown will be revealed or remain concealed. And that anticipation sustains attention even when details are complex, because complexity itself becomes part of the intrigue. And as the case inches forward, the sense grows that whatever the court ultimately decides will be interpreted as a statement about priorities, whether the priority lies in shielding discomfort or upholding openness. And that interpretation will echo beyond this dispute because it informs how future cases are perceived and how confident the public feels in the system's ability to treat all parties equally. And that confidence is fragile and easily shaken, which is why moments like this carry weight far exceeding the immediate facts. And that weight is what keeps this story alive and ensures that audiences continue watching, listening, and analyzing until a definitive line is drawn and the tension finally resolves or transforms into something new. As attention builds toward what may come next, the focus increasingly turns to consequence, because every legal strategy carries ripple effects that extend beyond the immediate filings. And those ripples are now being felt across public discourse, as viewers begin to recognize that this dispute is not simply about what happened in the past, but about how accountability is navigated in the present and future. And that recognition elevates interest because it transforms spectators into stakeholders who care not just about outcome but about process and fairness. And when process appears opaque, concern grows, and concern fuels continued engagement, because people instinctively want to see whether opacity will be challenged or normalized. And that tension is heightened by the realization that courts often move slowly, while public attention moves quickly, creating a gap where speculation thrives. And that gap is currently wide because the sealing debate has paused clarity without resolving it, and pauses in high-profile narratives rarely lead to disengagement, they lead to anticipation. And anticipation is one of the strongest drivers of sustained viewing, because it promises revelation and resolution even if delayed. And as analysts discuss potential outcomes, they often return to the same core issue: whether the court will reaffirm the principle that public access is fundamental, or carve out broader exceptions that could reshape expectations. And that choice carries symbolic weight because symbols matter in law not as decoration but as signals of values and priorities. And when values appear inconsistent, confusion follows, and confusion undermines trust. And trust is essential to legitimacy, and legitimacy is what allows decisions to be accepted even when unpopular. And that chain of reliance explains why transparency is defended so vigorously by those who view it as non-negotiable. And as the arguments are weighed, it becomes clear that this is not a binary struggle between privacy and exposure, but a nuanced negotiation over where the line should be drawn. and who gets to draw it, and lines once drawn tend to persist, shaping future behavior and informing strategy, and that persistence is what makes the present moment feel consequential, because it sets expectations for how similar disputes will be handled going forward, and whether parties will view sealing as an exceptional remedy or a routine tactic. And the latter scenario raises alarms because routine secrecy erodes the informational foundation upon which public understanding rests. And without that foundation, discourse becomes fragmented and polarized, driven by assumption rather than evidence. And that fragmentation is already visible in how narratives are forming around this case, with different groups interpreting limited information through divergent lenses, and as long as information remains limited, those lenses will harden rather than converge, and that dynamic benefits no one, because it replaces shared facts with competing stories. And courts exist precisely to establish shared facts and resolve disputes based on them. And when access to those facts is constrained, the court's role is diminished in the eyes of the public, even if its authority remains intact. And that perceptual shift matters, because authority without trust is brittle and easily questioned. And rebuilding trust requires not just correct rulings, but visible commitment to openness and fairness. And that visibility is what is currently under examination, because the sealing request tests whether commitment will be demonstrated or deferred. And as this test unfolds, observers continue to analyze language, tone, and timing, searching for clues about intent and trajectory. And those clues are parsed because people want to anticipate what the court will do and whether momentum favors disclosure or concealment. And that predictive engagement keeps interest alive because it invites viewers to become analysts themselves, weighing arguments and imagining outcomes. And that participatory aspect of high-profile cases is what sustains them over time, because audiences feel involved rather than passive, and involvement deepens investment. And investment resists fatigue, and as long as new filings continue to add layers rather than strip them away, the story will persist, because complexity generates discussion, and discussion generates community, and community sustains attention. And at the center of it all remains the unresolved question of what the sealed material would reveal, and whether its release would clarify or complicate understanding. And that unresolved question acts as a gravitational force, pulling focus back again and again, because humans are drawn to the unknown, especially when it appears deliberately withheld. And until that unknown is addressed, either through disclosure or definitive denial, the tension will remain, because ambiguity is fertile ground for speculation, and speculation is the engine of sustained interest. And as the legal process grinds forward, that engine continues to run, fueled by every delay, every argument, and every contested line. And the outcome, when it finally arrives, will not simply close a chapter, it will redefine the narrative, because it will answer not just what happens, but what matters. And that answer will linger, shaping perception long after the immediate dispute fades. And that enduring impact is why this case continues to command attention, and why viewers remain watching, waiting, and debating, unwilling to look away until the balance between secrecy and openness is finally resolved one way or another. What ultimately makes this situation so compelling is not the personalities involved, but the principle being tested in full public view, because this dispute has become a measuring stick for how transparency functions when pressure is applied, and whether the legal system remains consistent when influence and reputation enter the equation. And as the arguments unfold, it becomes clear that this is about more than documents or messages. It is about confidence in a process that depends on openness to maintain legitimacy. And when access is restricted, questions multiply, and those questions do not fade with time, they grow louder, because uncertainty invites speculation, and speculation fills the space left by silence. And that is why each decision made here carries weight beyond the immediate parties involved, because it signals how similar conflicts may be handled in the future, and whether public accountability remains the default or becomes negotiable. And while courts must balance competing interests, they also bear the responsibility of demonstrating fairness, not just through rulings, but through visible commitment to principle. And as viewers continue to follow this case, they are not simply waiting for a legal outcome, they are watching to see whether transparency is upheld or whether exceptions expand. And that distinction matters, because trust in the system depends on consistency and clarity. And when those qualities are reinforced, confidence strengthens. But when they appear compromised, skepticism takes root, and once skepticism spreads, it becomes difficult to reverse. And that reality underscores why this moment feels pivotal, because it sits at the intersection of law, perception, and public faith. And regardless of how the dispute ultimately resolves, the conversation it has sparked will endure, shaping expectations about openness, accountability, and fairness, and reminding everyone that the strength of any system lies not only in its rules, but in its willingness to apply them evenly, even when Doing so is uncomfortable.